Thanks very much, Gemma. Afternoon, everyone. Hope you're all well. Today we are looking at the exciting topics of works information and site information. Now, I think we can comfortably say that these documents are documents that you're probably far more comfortable with than I am. But what I'm looking at today is how they fit into the NEC form of contract. Things you need to look at in terms of both when you're negotiating your NEC contracts and also when you're looking at your compensation events, claims, potentially adjudication, and settling claims. And how these two documents fit in with the other documents within NEC, things you need to look out for, and what needs to be included within these documents. The works information is effectively your scope of works. So I suppose under JCT, it's the employer's requirements, contractors' proposals. Site information is what it says it is. It is information about the site. So that is predominantly the extent to which the party doing the work, contractor, or obviously subcontractor under a subcontract, the extent to which you're going to be responsible for ground conditions that you find. And of course, if we're looking at JCT, of course, JCT, when it's unamended, makes no reference to ground conditions, and that's simply because it's pretty much contractor's risk. So with NEC, there is potential for the contractor, subcontractor to avoid some of that risk through the site information, and we'll see how that works. So bear in mind with NEC, what other documents do we have? Well, we have the NEC form of contract, those standard clauses. We also have the Z clauses, which are effectively the amendments to the standard clauses. Please be really careful with the Z clauses nowadays. 5 years ago, there was never anything very much of any real interest in there. Yes, you might see, some anti-bribery provisions, data protection provisions, but nothing actually altering the legal risk between the parties. In the last 5 years, we've basically seen the NEC Z clauses becoming pretty much like schedule of amendments that we see with JCT, pages and pages of actual changes to the NEC contract, and therefore changes to the risk that the parties are taking on. Now, let's be realistic here. Who normally prepares these amendments? Well, it's usually the paying party. So where's the risk going to change? Well, it's going to change in favour of the paying party, i.e. putting more risk on the party doing the work, so the contractor or the subcontractor in a subcontract scenario. So, please do look at those Z clauses. They are important. And I'm going to kind of mention some changes that we see that impact on issues within the works information and the site information. Also bear in mind, you might have an activity schedule or a bill of quantities if you're on options A, B, C or D. Just be careful with that, because both of those documents, activity schedule is basically slicing up your fixed contract price to set out how you're going to be paid. Ditto your bill of quantities. These documents aren't about what work are you doing and what standards of care, etc. They're all dealt with in other documents, predominantly the works information. So activity schedule, bill of quantities, they're just about pricing. What do you get paid and when? It's not about the scope of your work. I've also got the contract data parts 1 and part 2. So they're the bits that are filled in. So project specific information like, how much are the delay damages, what's the start date, what's the completion date, how much insurance is required, things like that. But again, often ties in with works information in particular, and other parts of the contract. And also, let's remember as well, we either have a programme in the contract, which is the accepted programme, or hopefully we have one shortly after the works start. Bear in mind, the accepted programme is a really, really critical document in NEC. And again, we're going to look at how that plays into the works information, site information, risks, and of course, ultimately, whether or not contractor or subcontractor is going to be entitled to a compensation event, which, hopefully, as we know, is the trio of payment for extra work, extra time, and getting additional time, so an extension of time. So those three items. So programme is really important. The guidance notes, I always mention the guidance notes to NEC, just simply because they are actually, on the whole, quite useful. They are particularly with regard to the works information, because it basically contains a shipping list. A shopping list of all the issues that need to be included in the works information, and that is quite important. That is how the NEC form of contract works. So it's important that these issues are covered. Site information. So I want to look first of all at how the NEC contract defines site information and works information, and then we'll go on from there to see how they're dealt with within the contract. So site information is defined at clause 11, which are the definitions, 11.2. So 16, so it's the 16th definition, and basically it says site information is information which describes the site and its surroundings and is in the documents which the contract data states it is in. So mentioned already, contract data bit, the bit of the contract that you fill in. So the site information is identified in part 1 of the contract data. Who fills that in? It's the paying party, so the employer in a contract and the contractor in a subcontract. So when you're reviewing your contracts, you need to check that. You need to check contract data part 1, see what it says the site information is, where you find it in the contract, and what it says. So site information, what kind of information will it include? Well, it could include investigations, test results, the usual site investigations that you would expect the client to have carried out prior to putting the work out to tender, because of course the less of that there is, the more that the contractor is going to have uncertainty in the work that it's carrying out, and therefore have to factor it into its price. So physical conditions of the site. Also, it may include publicly available information about the site and surroundings. I've not seen that very often personally in the contracts I've seen, but bear that in mind, because that is a risk that the party doing the work, contractor or subcontractor, does bear on in the NEC contract. So all sorts of information about, particularly what is under the ground, but the site generally. As far as works information is concerned, again, this is defined in clause 11. So it's 11.219, so it's the 19th definition. And what it says is the works information is information which either specifies and describes the work, so the scope of work, states any constraints on how the contractor provides the works, So, what constraints, what limitations are there? And is either, so where do you find it? It's either in the documents which the contract data states it is in, or, sorry, there's a typo there, it's an order, it's or in an instruction given in accordance with the contract. So, again, contract data part 1, who provides that? The party paying. So again, when you're reviewing your contracts, look to see in the contract data what the works information is, where you'll find it, so that you know exactly what it is. Bear in mind, of course, that if the contractor in a contract has some design, and the same applies if the subcontractor has design in a subcontract, then there's a part in the contract data part 2 to insert a provision to state what the contractor's design works information is. And that part is for the subcontractor or the contractor to fill in. So whoever is carrying out the design. Point here: be careful, because, as I've already said, activity schedule and bill of quantities, they're not works information or site information. So if there's something in there that, for example, says, I as contractor, I'm only, this is, £3,000 for 3 boreholes or whatever, and the works information requires more work than that, then, the works information is the work that has to be carried out. The activity schedule is for pricing mechanisms, so to determine when you'll get paid for when you've done the 3. So please just be really careful about that. So some potential issues here. Works information, they're a mixed bag, to be frank. I still see some really shocking works information documents, and some that are really, really good. Also, sometimes I think that contractors and subcontractors in a subcontract, sometimes don't interrogate the works information sufficiently. So we'll come on to that in a second. Ambiguities within each of those documents, again, that's to do with interrogating the documents and getting to grips with them. Typically, they will have been provided and substantially drafted by consultants on behalf of the employer. And we all know, lawyers know it as well as anyone. You've got to be really careful when you're drafting something, because you get so close to it that you don't realise sometimes there are ambiguities within the documents. And also the other thing is, sometimes the works information will be a number of documents, quite often prepared by different people. So, my advice to contractors and subcontractors is interrogate these documents. If there are ambiguities, raise them at tender stage. Typically, ambiguities are dealt with in a way that is beneficial to contractor, subcontractor, whoever's doing the work. But what we're seeing, I mentioned we're seeing substantial Z clauses amending NEC. And what we very much see nowadays with that kind of bundle of Z clauses of amendments is a clause that says, as we see with JCT, if there are any ambiguities within any of the documents, then it's the contractor, it's the party doing the work that takes the risk of any extra work relating to those ambiguities. So, I think it's always best to raise them, unless you are really, really clear that, ambiguities work in your favour within the contract. Make sure that the works information just are relevant to the work. What we see quite often is something that's clearly a scope of work drafted for a JCT contract, that should ring alarm bells when you're negotiating and reviewing a contract, because it might not contain all the list of things that the NEC guidance notes say that the works information should contain. If employer's consultant has just picked, a JCT scope of work off the computer, deleted the project specific information and inserted project specific for this project. They haven't prepared this for an NEC form of contract. They've prepared it for a JCT form of contract. That's fairly common. This one, then the third bullet point where I said e.g. related contracts for follow-on works. This was a works information that I had that was, apart from the fact that it was 2 large files of paperwork, the works information, the scope of work, and I was looking through it and it was completely confusing. And it wasn't until the client pointed out that it actually contained the client's scope of work for its contract, but it also contained another party's scope of work for other works that were being carried out and completed by another party, that it became clear why it was so confusing to me. Now, that wasn't helpful because there were parts in the section that was really aimed at another contract that didn't help my client's case. So just be careful about that. If that's how the works information is set out, first of all, try and get the bit that isn't related to your work removed. It just doesn't make sense to have it in. If they won't remove it, then at least get something to say, this section B, is not applicable. It's relevant to another contract and it's not applicable to your work, because you could find that there are bits in there, just fairly innocuous provisions about, compliance with British standards, design life, things like that, that if you get into a dispute, all of a sudden that might be used and it might work against the contractor or subcontractor. So just be careful about things like that. Just because, you guys will pick it up and think, yeah, that's obviously not for our project. Don't think, oh, well, that's fine, it can stay in. Yeah, be careful of works information duplicating contract provisions. That's never great, because that then brings us back to ambiguities where they don't quite duplicate accurately and you end up with ambiguities. And oh yeah, the last point. So, another big issue, what we often see is contractors and subcontractors tender for work. They have a really lovely list of caveats, things that aren't included in their price. Quite often, we're not, price doesn't include, any extras for ground conditions. There may be all sorts of caveats. That's the basis of the price. And then when the contract's put together, none of those caveats are taken into account. So what happens there is that the paying party gets the benefit of a really nice, honed down price, but the contract risks aren't changed to take account of the fact that that honed down price reduces the risks that the party doing the work is carrying out. So, if you're putting in a schedule of caveats, please make sure they're incorporated into the contract. Also, so that's the first thing, but be careful how they're incorporated, because the next risk is that they're incorporated just as they've been prepared as a list, so they're not properly drafted. The risk is that they just get put in as a document. It's a document that goes at the end of a list, and therefore, takes least priority over all the documents. So again, if there's an ambiguity with the contract document or the works information, you might find that your caveats, are of little effect. So that's the first point. And also, really those clauses, the caveats need to be drafted properly and incorporated into the Z clauses, so the amendments to the NEC. And also you need to consider the pre-existing clauses, just to make sure that you don't have a pre-existing clause that says one thing, and your caveat goes into a Z clause, says another, because again, you've then got an ambiguity. So, this is why all those years ago when NEC was set up, that they said, that this clause should not be amended, because sometimes amending it causes more problems than you're trying to solve, because you're amending to try and hone down the price. But if it's not done properly, you might find that you're still responsible for those issues, but obviously you haven't priced for them. So please be careful about that. So what does the works information cover? Well, it covers the plant and materials. So, the specification, the requirements that the employer has, the type of materials it wants you to be used, etc. Also potentially delivery and storage specification. What else will it include? And this is all, I should say, this is all set out in the guidance notes for NEC. So it covers any element of the contractor's design. Now, if as a contractor or subcontractor, you're not carrying out any design, what I really like to see is a clause in the contract, so Z clause, saying, very, very clearly that contractor has no design responsibility and has no liability for any design. Because even if there is no design responsibility, what you sometimes find, contractors and subcontractors, if you're guilty of this, is being really helpful and trying to sort things out, trying to sort problems out when they crop up partway through the works. And contractors and subcontractors in doing this sometimes end up in carrying out design work even when they're not contracted to, and it's all done to be helpful, but you need to be careful about that, because if you're doing the work, then typically under the law you will find that you're responsible for it. So a clause that says you have no design liability, you're not responsible for any design, even if you carry out any, is quite a nice clause to make it clear that the intention is there's no design liability. That's, any design changes are the responsibility of the employer. But B, if you inadvertently, are helpful, you should be covered. You're not liable for that design. Just be wary as to how design is set up in the works information. Does it say something like, contractors responsible for all design except, the following A, B, and C, which the employer's designed, which is a very wide design provision for contractor and subcontractor in a subcontract, because it's basically you are responsible for everything with the exception of A, B, and C. A preferable way of doing it for a contractor or subcontractor and a subcontractor is to say employers carried out all the design, the contractor's only design responsibility is A, B, C. So that that's the limit of your design responsibility. And then the final bullet point, as we will see later on when we're looking at compensation events, so extra money for changes to the work scope, extra time, an extension of time effectively, and compensation for the additional time that you're on site. So 60.11, which deals with a change to the works information, being a compensation event, specifically states that where it's a change in the contractor's design or subcontractor's design in a subcontract, isn't a compensation event, for obvious reasons, I think. So just continuing the design, these are a list of all the things that the NEC lists as design issues that should be specified by the employer to state exactly how it wants the design to work. Other things that need to be included in the works information: copyright issues and health and safety issues. Typically what we see with regard to copyright is that it's actually amended into Z clauses because it's considered a legal point rather than something in the works information. Really, really important, this one, working with the employer and others. So others with a capital O is defined as pretty much the employer's people, so people the employer is paying. So it might be employers' consultants, assuming they haven't been novated to the contractor, of course. Third parties, effectively. So working with the employer and others, of course, as with my project, which included 2 sets of works information in one, there were effectively two contractors working on the same project. So it would include that scenario. They would be covered as others. So the employer is supposed in the works information to set out, how the parties will work together, times and dates. Other parties and the employer will require access to the working areas and to the site to carry out their work, so that everything's well coordinated. Bear in mind this final bullet point, and we're going to come to these later, it's a compensation event. So extra time, money, and loss and expense on money relating to the time to the contractor if the employer or the others don't stick to what is stated in the works information. If what's in the works information is very vague and broad, then that's not great for the contractor, because you've got nothing to hang your hat on if you want to make a compensation event, because you can't say the employer has failed to comply with the works information if you've got something that just says, the employer and others will be generally on site, they'll be generally working, and contractor, you as contractor have to work around them. That's basically pushing all that responsibility on you. And it means that you've got no way of claiming a compensation event, because you can't say, oh, employer hasn't complied with this clause, because they're just generally allowed on site, generally allowed in the working areas, etc. And that is usually what I see. So just be careful about that, because that is pretty much changing the risk. NEC anticipates that the employer will have some kind of strategy so that all the parties know where each other are working and can work around each other, rather than just, well, everyone's going to be on site, so just get on with it, and contractor, you take the risk. Subcontracting, it may have a list of acceptable subcontractors for particular specialisms. That's really, really common. But again, what I'm seeing recently is real problems being caused by those subcontractors, which always feels very unfair as a contractor. Employers pick those subcontractors, they then cause problems. Sometimes their loyalty is actually with the employer because they have a relationship with them. And, I've seen contractors, find it difficult to manage them because they're used to working with the employer, so the subcontractor goes direct to the employer, and there can be all sorts of issues there. So just be careful about that. Albeit that it's just a really common thing, both in NEC, JCT, construction generally. Be careful, because the works information might set out details of work that may not be subcontracted. So just be careful about that. And also work which must be be subcontracted. So, you know, be careful about that. You know, if you go on and subcontract work and the works information says that you can't, then, you know, it's the same as with any other contract. You've not complied with the contract, and therefore it's a breach of contract, and the employer can claim damages that result from that breach. Completion and programming. Now, I mentioned programming previously. So the works information, so we know that the contract data part 1 will set out the start and completion dates, so that you know what dates you've got to comply with before you're incurring delay damages and having to pay them to the employer. But the works information, and this is quite a nice example of how all these documents mesh together. You can't just read one and think, well, that's the scenario, that's the situation, fine. The works information should state the work that has to be done by the completion date, or by sections if option X5 applies, where you've got sectional completion. That's quite important, and it could be very important for specific types of work. And in addition, what the works information could say is, that there's a list of works that can remain incomplete when you get your completion certificate. So that's really important, because obviously you don't want to find that you're paying delay damages, because you thought you only had to complete certain elements of work, and some parts could be completed post completion, but that wasn't the case. So just be really important about that. It may also include information that the contractor is to include within its programme. Already said that the programme is a key document in NEC. It's absolutely critical to getting any extra time. So any compensation event where you're wanting an extension of time, your accepted programme is critical. Bear in mind that if the works information includes information that's required to be included in the programme, that also clause 31.2 of the contract includes a whole shopping list of items that are to be included, and quite often the Z clauses add to that as well. So, again, unfortunately, you need to jump around this contract to see everything you need to include. Testing and defects. So testing, first of all, works information needs to set out what tests need to be carried out, what results need to be achieved, and usually this will be critical for getting a completion certificate or a notification that you've completed the works and the defects periods to start. So it should include the detail of the tests the contractor has to carry out. Also details of any tests employer has to carry out, also details as to who provides all the materials, facilities, sampling for tests, also any specific tests that have to be carried out on any part of the plant or materials before they're delivered to site, before they're delivered to the working areas. So that would probably be more about something that's being manufactured off-site. So, again, you need to review this pre-contract because it's all important stuff. So the failure by the employer to comply with these provisions is a compensation event. So that's compensation event 16, as you can see at that bottom bullet point. So basically what that means is that this provision has to set out what tests are to be carried out. So if, for example, contractors to carry out a particular test, but employer states that it states in the works information that it will provide certain materials so that test can be carried out. So typically waste to energy plant, the testing is the contractor's responsibility, but usually the employer would provide the waste. So you'd expect that to be contained in the works information. If the employer failed to provide the waste, they've not complied with the works information in that respect, and therefore it's a compensation event in accordance with 16. Contractor then gets the cost of, you know, that test, which probably wouldn't be able to go ahead without the waste. So the cost of people on site, the extra time, get an extension of time to avoid delay damages, etc. So, you know, if this is, you know, critical to you, you know, you need to think about this. You know, if you need any particular materials or sampling or whatever provided by the employer, you know, you need to think about that and make sure it's clearly set out in the works information, because again, if it's not clear, you've nothing to hang your hat on in terms of claiming a compensation event. In terms of defects, so where it talks about 44.1 and 44.2, that's a reference to the contract clauses in NEC, which talk about the ability of the project manager to accept defects and make a deduction to the sum paid to the contractor, to take into account the fact that the employer's getting something that isn't quite right, but, you know, everybody's, you know, reasonably happy that, you know, the defect, you know, it doesn't really need to be corrected for whatever practical reason. For obvious reasons, that's not a compensation event. You're not going to get extra time or extra money if your work's defective, and the employer accepts that as a concession. So just moving on to the compensation events to look at them. So from the other side of the coin, the relevant ones are compensation events. So the clause is 60.1 for compensation events. Don't forget that there are other compensation events in the option X clauses, but we'll touch on them in a minute. They're probably less relevant. But the ones that are relevant to the works information are, as it says here, 1, 5 and 16. Number 12 is relevant to the site information. Just bear in mind, this is clause, the second bullet point, so clause 63.8 of the contract. I've already touched on this, but what the contract says is that where the compensation event to change the works is to change the works information. So it's 60.11, that first compensation event, because it's to resolve an ambiguity or inconsistency within the works information. Then the alteration, that trio of prices, completion and date and key dates, and loss and expense for the extension of time, those 3 points are dealt with so that they're favourable to the contractor, and that's because, you know, it's not the contractor's document, it's the employer's document. So logically, employer takes the risk as if there's any ambiguity. So normally you're safe. I spent quite a while earlier, you know, saying look through, check if there are ambiguities, and raise this at tender stage. Why I said that is because what we're really seeing now is clauses, Z clauses, being added to the contract to say, actually, if there is an ambiguity or inconsistency with any of the contract documents, then the contractor bears the risk and bears the cost, bears the time of sorting that out, you know, at the discretion of the employer. So basically, employer decides which way it wants to go. You know, you've got works information. One part says do X, one part says do Y. That's an ambiguity, and the clause basically says that project manager stroke employer decides which one contractor has to do, and the contract has to do it, and it's the contractor's risk. So employer can decide that they do the more expensive one, and that's the contractor risk. So just be careful with that. You know, you could read the works information and think, oh yeah, I see there's an ambiguity, but I know NEC really well, so I know that goes in, you know, that would go in my favour, and I'd have to do, you know, whichever work I do, I get paid for, you know, it on the basis that, you know, I've costed the one that's the cheapest for me, basically. But, you know, if you've got one of these Z clauses in, that's actually not going to be the case, and you might end up in trouble. So we've looked at all of these already. So these are the compensation events. So number one, I mean, this is pretty much word for word. So the project manager instructs a change to the works information, and it's accept a change to correct a defect. We've already seen that, or to ensure that the contractor's design complies with the works information, and we've already seen that. Remember, contractor's design is referenced in the contract data part 2, works information is referenced in the contract data part 1. So compensation event 60.1.5 is this one that we've already seen about the employer or others not working within either the conditions set out in the works information or carrying out the work on site as set out in the works information. But be really, really careful, because the compensation event can only, as I say, you've only got something to hang your hat on if there's detail in the works information, so that you can say, you know, the works information said the employer would only ever be doing work to, you know, that far, you know, northeasterly section of the site marked blue, you know, and they strayed out of that part of the site and they disrupted our work, and therefore that's a compensation event under this 60.15. If the works information just says, you know, employer will be generally milling around on site at all times, and you know, you cannot ever say, oh well, you know, that they disrupted our work, because, you know, the works information allows them to be milling around on site at all times. And the final one, 60.116, the employer fails to provide those materials, facilities, samples, you know, anything for testing as set out in the another typo, as set out in the works information, the WI. So again, you know, it needs to be specific so that you can say, you know, we were going to test, the works information said that the employer had to provide, you know, certain materials, you know, the waste to go through the process, failed to do so, you know, and therefore it's a compensation event. We mentioned compensation event 12, that relates to the site information. So that is the relevance of the site information. Slightly convoluted provision. So what this is you get a compensation event, so that trio of time, money relating to the time and your extra cost on site, in the following situation. So you've encountered physical conditions. It's not got to be weather, so bear that in mind, because there is another clause that gives you, in very, very, very awful weather, you know, even awful by, you know, our standards, there's a separate provision. So this is physical conditions on site, not weather, which an experienced contractor would have judged at the contract date, so that's at the start of the contract, that it would have such a small chance of occurring that it would be unreasonable to have allowed for those physical conditions in your price. So bear that in mind, because it does give you some wriggle room. It's not saying, you know, you should, you know, have priced for it. It's slightly more nuanced than that. And, you know, as I say, it gives you slightly more ability to make a claim. But you've got another hurdle to get through. You've also got to show that in judging those physical conditions, so when you think about your physical conditions at the start date, you know, it's obviously an experienced contractor. So this is about your judgment. So where it says in that first bullet point, would have judged at the contract date that it would have such a small chance of occurring, you know, this can't be, you know, you saying, well, I'm a very experienced contractor and I didn't think, you know, we'd have any problems with the ground conditions at all. You've got to have made a reasonable value judgment based on the following. So in judging the physical conditions, contractors deemed to have taken into account the following. So the first one is the site information. So that is why the site information is in the contract. Be careful, because what we're seeing now is that common JCT clause within the Z amendments, which says any reports, any site information that's in the contract, employer takes no liability for it being right or wrong, negligent, you know, negligence or otherwise. So just be careful about that, because again, that's an attempt to shift the risk, you know, and make it less likely that you'd be able to make a claim under this compensation event. So that's one lot of information you need to take into account. Also, publicly available information. I don't know whether you consider that when you're looking at your tenders, but you should do, you know, you should be doing a Google search, also thinking about, you know, work that you may have done on that site in the past. Information from a visual inspection, that's super, super important. And then any other information which an experienced contractor could reasonably have been expected to have obtained. Not sure exactly what that would entail, because you've got publicly available information and visual inspection. I suspect actually it would potentially include things like, you know, possibly you did work, you know, it's part 2 of a project where you did the work for part 1, something like that. So that's all of the information that so you've got to tick all of those boxes and show that even considering all of those issues at the contract date, you know, you were reasonable in thinking that what has happened on site in this instance had such a small chance of occurring that it would be unreasonable for you to allow for them. And it's quite nicely drafted, that this unreasonable for you to allow for it, because, you know, what you can do is put it back to the employer and say, well, you know, what would you have done if I'd added, you know, £500,000 onto the contract to take account of, you know, these ground conditions at the time, when, you know, none of us, you know, had anticipated them happening. So, you know, it's quite nicely worded, I think, to be quite persuasive, or to allow the contractor or subcontractor and a subcontractor to be quite persuasive in showing that it's entitled to the compensation event. Again, we've got the same ambiguity provision. If there's an ambiguity, you assume the contractor's priced the lowest cost item. So if you have to go with the higher cost item, that's covered in the compensation event. But beware again of that Z clause that's often included that we've referred to already. Just to remind you about the optional provisions that may relate to the works information. So X4 is requiring a parent company guarantee. The works information is supposed to state the terms required for that parent company guarantee. So just be careful there, because if it's not in, you could end up with a little bit of debate stroke argument as to, you know, how tricky a PCG is required. Excuse me. X13, ditto with the performance bond. X14, advance payment bond, probably pretty super rare, I would say, for you guys. And then X17, performance tests if you're having performance damages in the contract. Again, I suspect that's pretty rare for your contracts. One thing to be careful about is a joint site information and works information. You just need to think about how that impacts on your work. Usually it favours the employer more than the contractor, because it just means that it's so much wider for the contractor to comply with, particularly if that ambiguity clause has been changed as well. So in conclusion, works information is really important. You know, I hope today has shown that, also the site information, and hopefully you've seen from the site information, you know, how you know, you can make a claim, whereas with with JCT, contractor pretty much takes the risk of the site conditions. Be careful with both about amendments to the Z clauses, particularly, you know, that compensation event 12 for site conditions is often just removed so that the contractor is fully responsible for whatever it finds on site. And do discuss this with the employer at tender stage. Point out that, if clauses like clause 12 are removed, if they want contractor to be responsible for all ground conditions and take that risk, then, there is a price for that, because, who knows what will be found on site. That's one of the big unknowns in construction. So in terms of the works information, just bear in mind, how it defines contractors' scope of work and responsibility, and how important it is in respect of claiming compensation events, so entitled to delay damages, and also finally, contractors' responsibility for defects. So that's everything. We've got the top bit. I put my mobile number on there, so if anyone's got to get off and has any questions, feel free to give me a ring. My email should be on there, so apologies it isn't, but if you look on our website, you'll find my email if you'd prefer to drop me an email. And then the bottom half of the slide is about the certificates for the My Pro Pass that Gemma was talking about. Please don't ring me about them, because as Gemma knows, my IT skills won't cater for certificates by any means.
Thank you, Sarah.
So,
we have got a couple of questions, if that's okay.
Hi, Ryan. Sure, yeah. If section work is complete, say today. First of all, the works information states that the standard requirement. Yeah, that sounds like it's a bit of a circular thing, isn't it? So if you're the contractor here, you're wanting completion, I think you're probably okay. It looks to me like you've got works information that says you get sectional completion for a piece of equipment, but it can't be commissioned until 12 months from completion. Or until it's been used for 12 months. So unless there's very clear wording there, I think you're probably okay. You should get completion, and then the commissioning takes place 12 months later. If the wording's not so clear there, I suspect the court would take a fairly common sense approach. The law does change quite subtly, it sort of evolves, but at the moment, the way the courts are interpreting contracts is they're saying they're using a business common sense approach. Now, what that means, that leaves it open fairly widely. But to me, this fairly and squarely fits within that, business common sense. If you're aiming for completion by a certain date, and then it's going to be used for 12 months, or for whatever reason, commissioning can't take place until 12 months later, then I think if the wording isn't very clear, a court would step in and use this business common sense approach and say, come on, guys, let's be sensible here. Clearly, you can't be claiming any damages waiting for commissioning to take place, because it's a bit of a chicken and egg. So hopefully that's hopefully I've interpreted that question correctly. Hi, Chris. So in terms of the site information, i.e. as-built drawings, if the as-built, but from an on-site survey, right, okay, so this is, so you're doing work to an existing structure. Yeah, I would imagine this is where you can tell I'm not so we've got 1,000. I think you've sort of got a conflict, because your site information says one thing, but your visual inspection says another. So I think, yes, your inconsistency clause will probably help. And I think you've also, got an argument about, what would you have reasonably done and priced for as at the contract date. And I think unless, a difference of 500 mils isn't a lot, is it? It's 50 centimetres, I think, yeah. Which isn't a huge amount, so unless there's a really strong argument to say, oh, come on, guys, a visual inspection would have easily revealed this, then I think you've got a good argument that actually a visual inspection, wouldn't reveal something like that, because I kind of think a visual inspection isn't, going around with, you tape measure and, your microscope to check everything. It's more to check out things that you can't find from the actual information that's provided in the site information. So, I'm pretty sure that the contractor would be okay on that one on a couple of bases. First of all, you've got the ambiguity. Secondly, I think you'd argue, a visual inspection isn't supposed to be spending 3 days, checking that the site information is correct. It's meant to be looking for other things, and certainly not something, maybe, checking that, if the site information, said a kilometre, and it was obviously some, a metre or something really daft like that, possibly, the site, a visual inspection, you should be expected to see that, but not with something that's, a relatively small measurement. And I think also the third argument would be, well, hang on, what were we pricing at the time? What reasonably were we pricing? And I think if you were to say to the employer, what did you think we were pricing, then they would think you were pricing what was in the works information. So, I think contractors should be okay on that one. Well, Chris, yeah, that's a good question. And this is a good example of where, you're creating problems by tinkering with the NEC form of contract, and why the people at NEC have always said, don't tinker with this contract. We like it as it is, and you should use it as it is. If you wouldn't, well, I would expect an order of precedence within the works information to set out, to deal with all of the documents within the contract. So I wouldn't expect a works information document itself to say, you know, the order of precedence within this works information is that, you know, section 6 of the works information comes first, section 3 comes second, etc. I would expect that order of precedence to deal with the contract documents as a whole, to say, well, number 1 is the agreement that we've signed, the deed. Number 2 would typically be the Z clauses. Number 3 would be the contract clauses. Probably number 4, the contract data or the works information. So it would be dealing with those documents. And in that case, if that's the case, if you've got an ambiguity within the works information, your ambiguity clause that you're talking about has no effect, because the ambiguity is within the works information. So you go back to your standard NEC where it's interpreted that the contractor has priced the lowest of the 2 ambiguous clauses. If it is, as I said initially, where you've got your works information, 6 sections, and it says section 6 takes precedence over everything else, and section 6 has something ambiguous with the rest, then you've sort of got a double ambiguity, unfortunately, because you've got an ambiguity within your works information. But how is it dealt with? Well, you've got the works information saying you've got an order of precedence, but you've got a clause in the contract that says it's dealt with in the contractor's favour. So you've got a muddle. So you need to then look at, have the Z clauses been amended to say that there's an order of precedence? So if the works information takes precedence over things, over the contract, so if the contract takes precedence over the works information, then the usual standard clause that says contractor doesn't take the risk, contractor gets paid for any ambiguity, then that takes precedence over your works information clause dealing with precedence. So hopefully you've understood that, Chris, but hopefully it also shows what a muddle you can get into by tinkering with the NEC form of contract.
Thank you, Sarah. I think that's us for questions today. Thank you very much for your presentation. Thank you very much for the questions, and thank you to everyone for attending this afternoon. As we've mentioned, we do have access to the MyProPass account, which we'll be trialling. If you would like to receive a certificate through MyProPass, all the details are here, and they'll also be in the email that you get sent out as well after the event today. So feel free to go on there and download your CPD certificate. If anyone's got any issues regarding the events, seminars, webinars, ideas for future events, please feel free to drop me an email. You should all have my contact details. Obviously, if you've got issues regarding NEC, Sarah's contact details are there. So please feel free to not muddle us up and contact Sarah for anything contractual. Thank you very much, everyone. You should all receive automatic invitations to our next event coming up. And also, I'll send a link which should have details of all webinars and seminars that are coming up across the SEEK Northern regions. Thank you very much. Great to see you all, and we will speak to you all soon. Thank you very much.